Hi, everyone. My name is Matt Underwood, and I'm from Underwood Legal LLC. I'm joined today by Aaron Ogden. Aaron is a business and intellectual property attorney and a partner of Ogden Glazer Schaefer here in Madison. Thanks for joining us, Aaron.
Thanks so much for having me, Matt.
Well, as an estate planning and elder law attorney, we oftentimes have cases that involve areas outside of estate planning and elder law, including intellectual property and copyright issues. And so when that happens and we have those new legal issues come across our desk, I want to enlist the services of another attorney who focuses in those areas. And so that's why I wanted to bring you on board to help out with our connection between estate planning and intellectual property. And in this three-part series, Aaron and I will discuss the intersection of estate planning and intellectual property. So we'll go over things like what are copyrights, how are they different from other assets, what are some potential pitfalls when planning for copyrights, and then how can estate planners effectively plan for clients with those intellectual property issues. So in this first video, Aaron, I just wanted to discuss what a copyright is and how it's different from other client assets, such as a home, bank account, or investment account. So Aaron, if you could get us started and at least let us know what exactly is a copyright.
Absolutely. So, like you said, it's a form of intellectual property protection, which, to put in English, it's protecting some of the stuff that you own because you're creative and you built something with that creativity. So, copyright law protects a creative expression of an idea. So, when you think about that's paintings, photographs, books. And so, it's kind of a bundle of rights that says once I create that book, that masterpiece, whatever that is, I have a bunch of rights that now come along with that. So I have a right to reproduce that work. I have a right to prepare derivatives or modifications from that. So if it's a book, I have the right to decide if a movie is going to be made from it or a sequel to that book. I can also decide who gets to distribute that, who makes uh, various copies, who can perform the work. So if it's a play, who can actually perform the play or the music, or who can't, and also who can publicly display that. That happens a lot, again, with photos or sculptures or things like that. And so it's different than a lot of things because you can't really put your hands on it. Like you were talking about a house. Like I can point and say, that's my house. And I can't really carry it along. And it's really, really hard to copy my house, right? But something like a photograph or music, especially in the digital world, it's really easy to make copies of it. And so it becomes more important to know who owns those rights and how to do it. And so we want to know what those rights are and who has those rights. And the interesting thing is, I say it's a bundle because you can give out each of those things individually. So, for example, if I create a hit new series of novels, I can be the only one who can write sequels for it. Or I can have, for example, the girl with the spider or the girl with the dragon tattoo. The author died, and so his estate actually let somebody else write a fourth book with that series. They gave away the right for making those derivative works. Or I can say, I'm going to make the sequel, but I'm going to let you make a movie of it. Or I'm going to let you distribute, a publisher of it. So you really get to start picking out which ones of those are. Like I said, it's about that creative expression. It's about the story. Just because I own a copy of that book doesn't mean I own any part of that copyright. It just means I own that particular copy of that book. So I can't go to, Kinko's and make a copy of it and give it to my friend. Just like with back in the day, you may be younger than me in that you don't remember the Napster, Grokster heyday where you were copying all of those songs. Well, you're not allowed to do that, even though it's easy. Even though it made it, you could do it, doesn't mean you are allowed to do it. So that's why copyright can be a little bit different than a bank account or a house because it's much easier to make copies of it or infringe or build on all of those rights that is supposed to be owned by the copyright owner.
Well, that's really good to know. And it's helpful to understand that, as you said, it's easy to look at my house and say, okay, I'm taking this asset that I can see, I can touch it, and I want to do something with it. But it's a little bit different when it's the intangible property, like a copyright or other intellectual property. So, and there's, certainly a bundle of rights that just because it's intangible doesn't diminish the value of that asset
Mhm.
either. So I think that's
Sometimes it
really.
actually can increase the value, right? Because now I can have the rights to go to a movie, right? Or I can have multiple copies of it.
Right. And, along those lines, Aaron, one other area that I would say is at least a difference in terms of intellectual property assets or copyright versus some of the more tangible assets. And that is a termination right, it's sometimes called. And the way
Mhm.
I sometimes refer to it as a clawback provision. And jump in here, Aaron, if I'm off base here, but if somebody has a copyright, they can transfer that copyright, they can sell it, give it away. But with this termination right or the recapture right, that person could actually go back to who they gave that copyright to and essentially ask for it back. Or if somebody passes away, that copyright owner passes away, and now the spouse or children receive that copyright. I'm sorry, the spouse or children take over the estate. Those spouse or children could actually try to claw back that copyright as well. So am I on base there, Aaron, or anything
Yeah,
that?
in certain circumstances, that's possible. There is some limitation. There's some time limits, and there's some uh, things that it applies or not. And so that's why it's super important that people talk to estate planners like you, so they understand what what is happening with those rights, because they may not be around to say no, that's really what I want, or they might or not be able to express regret later. And so it's really important for them to understand what it is that they're giving away or selling or transferring and what they aren't. And then not only is it important for the copyright owner to know that, but also the person, the heirs, and the person who's getting it transferred. So if you say you're putting it into a trust, the trustee has to understand it, the beneficiaries of the trust have to understand it, and the owner. So there's a lot there that needs to be understood, and not just by the person giving it away, because they may not be the one making the decision when
Okay.
when those rights could be triggered.
Okay. No, that makes sense, Aaron. So far we talked about what copyrights are. It's an intangible bucket of rights. Essentially, you can give away some of those rights. You can retain other rights. So there's a lot of different moving
Even better, you
parts
can
to
sell
it.
it. You can make money on some of those rights or license of it.
Exactly. So I totally would agree with what you're saying. Is if you have these bundle of rights, or if you're involved, if or in your family, I think absolutely talk to an attorney who knows this area of the law and can advise you properly on that. So
Mhm.
in this part, we just wanted to introduce what copyrights are, some of the things to be aware of specific to that intangible property. And in the next two parts to this series, we'll talk about some of the pitfalls or what can happen if you don't properly plan for that copyright. And then we'll also talk about what estate planners should be aware of and how to properly plan for those assets. So Aaron, I wanted to thank you today for joining us, and we'll look forward to the next part in this series.